Okay, friends, are you sitting down? Donald Trump is trying to delay the appeal in his classified documents case. Shocking, I know. But actually, the more interesting feature of this legal development is that Special Counsel Jack Smith is not opposing the delay. But you know, given where we are in the Trump criminal cases at this moment in time, Jack Smith's decision not to oppose Trump's delay actually makes perfect sense. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, there's some new reporting about Donald Trump and his lawyers trying to delay the appeal in his classified documents case down in Florida. But before we turn to the new reporting, let's just kind of bring this issue into full focus. You undoubtedly remember that Special Counsel Jack Smith indicted Donald Trump and two co-defendants for unlawfully retaining classified documents, obstructing justice by refusing to return them when a federal grand jury subpoenaed their return, thereby obstructing justice, and violating our nation's espionage laws because of the nature of some of these classified documents that Donald Trump stole from the federal government and unlawfully retained. And then after Jack Smith indicted Donald Trump appointed Judge Aileen Cannon, who's presiding over the documents case down in Florida, dismissed, threw out, tossed Donald Trump's case, contrary to precedent and case law, up to and including Supreme Court precedent. She threw it out really with no legal basis to do so. Not surprisingly, Jack Smith appealed. He filed his brief. And now Donald Trump's brief is coming due in opposition to Jack Smith's brief in this appeal. It was due on September 25th, and Donald Trump's lawyers just filed something saying, wait a minute, we need more time. We need a 30-day delay before we can file our brief. And really the most surprising part, at least on the surface, is that Special Counsel Jack Smith said, fine, we don't oppose a 30-day delay. Under the circumstances, that was a smart thing to do. And we're going to talk about why that is, but let's start with the new reporting. This from the Washington Post. Headline, Trump requests more time to reply to appeal of Florida case dismissal. And that article begins, Donald Trump's legal team has requested a 30-day extension to respond to the government's appeal of U.S. District Judge Aileen Cannon's dismissal of his classified documents case, making it less likely that a ruling on whether the indictment should be restored will come before Inauguration Day. We're no longer talking about accomplishing anything in Donald Trump's criminal trials before the election in November. We're now talking about whether some of these things might be accomplished before Inauguration Day, January 20th. The article continues. The former president is very likely to be granted the extension. Special Counsel Jack Smith did not oppose the request, and the U.S. Court of Appeals for the 11th Circuit in Atlanta, where the government's appeal was filed, says first-time requests for 30-day extensions should be approved. Trump's lawyers said they can't meet the court's September 25 deadline because they're juggling other due dates related to Trump's separate federal election interference cases in D.C. They asked to move the 11th Circuit deadline to October 25th. So let's go right to this new court filing by Trump and his lawyers seeking this 30-day delay. In the case of the United States of America, plaintiff-appellant. Now, because the United States of America, the government, as represented by prosecutor Jack Smith, appealed the dismissal of Donald Trump's case, the United States of America is the appellant versus Donald Trump, Waltine Nauta, and Carlos de Oliveira, defendants appellees. Trump's motion is captioned, defendants appellees unopposed motion for extension of time to file opening brief. And unopposed is the most important word in this entire filing. We'll talk about why that is in a moment. Trump's motion reads in part, defendants, President Donald Trump, Waltine Nauta, and Carlos de Oliveira respectfully submit this motion for a 30-day extension of time to file their opening brief. Good cause exists for this request. The brief 30-day extension requested is warranted under the circumstances where President Trump, that's a typo, it should read former President Trump or Defendant Trump. Defendant Trump and his counsel are presently engaged in motion practice in a separate case brought by the special counsel in the District of Columbia, United States of America versus Trump. Defendant Trump and his counsel are also litigating issues in the U.S. Court of Appeals for the Second Circuit that require briefing in advance of a potential sentencing hearing, presently set for November 26th, 2024. And friends, I actually found it a little surprising that Trump's lawyers didn't even bother to mention his third criminal case that is ongoing at the moment, Trump's RICO prosecution down in Georgia. I guess that one is not taking up much of Trump's time and attention at the moment. But think about what his attorneys are saying in this request for a delay, right? Requesting a 30-day delay in filing their brief. What they're saying in substance is, Judge, our guy, Defendant Trump, is being prosecuted so much in so many places simultaneously up and down the eastern seaboard that, we can barely, come up for air. We are representing him in so many criminal cases at one time that, gosh darn it, we just need another 30 days before we'll be ready to file our brief in his Florida appeal, in his classified documents case. Okay, I get it. And the result will likely be more delay. But really, the most interesting feature of this legal development is that Jack Smith, special counsel, who I think we all recognize has been pushing these cases as fast and hard and aggressively as he can possibly push them, all of a sudden said, no opposition. We don't oppose Trump's request for a 30-day delay. I actually think that was a smart call by Jack Smith for three reasons, certainly in combination. Reason number one, timing. This is an easy call. There's no way anything's going to be accomplished in this appeal before the November election. There's no way much is going to be accomplished or is likely going to be accomplished before Inauguration Day, right? Because we still have Trump's brief that needs to be filed. Then Jack Smith will get a reply to that brief. There's another 15 days, maybe 30 days. Then they have to set it for oral argument. Then they have to conduct oral argument. Then the 11th Circuit Court of Appeals will take some time deciding the case, drafting, and issuing an opinion. So we are now well into 2025. So really another 30 days doesn't lose Jack Smith or the American people anything. So that's one reason he really need not oppose this delay. Second reason, I think, is what was probably driving this decision more so than anything else. This brief was going to be due on September 25th. But remember, friends, September 26th is a big day in Donald Trump's criminal cases writ large. Why? because that's the day that Jack Smith and his team of prosecutors will be filing a mega brief in Donald Trump's federal prosecution in Washington, D.C. for trying to overturn the results of the 2020 presidential election. That is the day that Judge Chutkan set for Jack Smith to file a big old brief that discloses all of Donald Trump's crimes, all of his conduct, all of his statements, so that Judge Chutkan can begin to litigate the question of which of his crimes, which of his conduct is official acts of a president, very few, or unofficial acts, the acts of a private person or a candidate, for which he can be criminally prosecuted. He doesn't have immunity. That is the task that the Supreme Court has handed to Judge Chutkan. So on the 26th of September, Jack Smith announced that he will be filing not only a big old brief disclosing all of this stuff, but he said expressly in a court filing, he's going to be attaching grand jury transcripts to that brief that he files. Presumably, this is going to be the testimony of the many Republican witnesses who appeared before grand jury and testified about the crimes of a fellow Republican, Donald Trump. He said he's going to be attaching transcribed interviews that weren't even part of grand jury appearances. He said he's going to attach to that brief FBI 302s. What are they? Well, when the FBI interviews a witness, they take very detailed notes and they put it all in what's called an FBI Form 302. So Jack Smith and his team are probably working round the clock between now and September 26th to make sure they give Judge Chutkan everything she needs, all of the evidence, so she can begin the task of trying to litigate and decide what Donald Trump should have immunity for and what should he not have immunity for. What should he be prosecuted for? So with that big old brief scheduled to be filed in Donald Trump's criminal case in Washington, D.C. on September 26th, it's not a surprise that Jack Smith agreed to a 30-day continuance in Donald Trump's deadline to file his brief in the appeal in the 11th Circuit Court of Appeals. Not a surprise at all. So the third reason that I think Jack Smith did not oppose this 30-day delay is when you're litigating cases, judges always want the parties to try to reach agreement, reach consensus on as many issues as possible. And I'll tell you, after appearing before well over 100 judges, state, federal, local, military, civilian, trial, and appellate court judges always appreciate when the parties can agree on issues so that the judge doesn't have to decide the issue and make one party or the other unhappy with the decision, with the ruling. And that is pretty much uniformly true. Every single judge I encountered so appreciated when the parties could reach agreement on issues and kind of moot it out so the judge didn't have to decide it. So when Jack Smith said, you know what, I'm not going to oppose Trump's request for a 30-day delay to file his brief, that tends to earn parties, prosecutors, defense attorneys, some goodwill with the court. Not a big deal, but, I always tried to agree with my, fellow defense counsel across the bar on as many issues as I could, without compromising the position of my client. Who was my client? Well, just as you've heard Kamala Harris say, her whole life, she had but one client, the people. As a career prosecutor, my client was always the people. And as long as I could reach agreement with defense counsel in a case and it didn't compromise the position of my client, the people, in our quest for justice, I did it. I did it early and often, and I can tell you every single judge appreciates when prosecutors and defense attorneys can reach agreement rather than forcing everything into this death match and requiring the judge to decide every issue in the case. There are lots of legal hills on which you don't want to die. So you agree as much as you can with opposing counsel. I think that's the third reason, and I think in combination, these three reasons make it clear that Jack Smith did the right thing by not opposing a request for a 30-day delay, even though people saw it, and instantly I started to see the posts and get the questions. Wait a minute, why is Jack Smith agreeing to a delay? That doesn't make any sense. We want these things to move quickly through the system. Yeah, well, does anything move quickly through the system when it comes to Donald Trump? But it will continue to move through the system. And I do believe the 11th Circuit Court of Appeals, once the case is submitted to them in full with all of the briefs and the oral arguments, they will do what the law requires, and that is to overturn Judge Aileen Cannon's decision to dismiss Donald Trump's case. They will reinstate the prosecution. I think the more interesting question, quite frankly, because that one is settled law. Judge Cannon should lose. She should be found to have abused her discretion again. The more interesting question is, will the 11th Circuit Court of Appeals also sua sponte, which just means on their own, without even being asked, will they also direct that the case be reassigned to a fair, independent, and impartial judge who hasn't been reversed time and again for doing favors for Donald Trump, favors that the law does not allow? That's what I think the 11th Circuit Court of Appeals should do. Give it to a new judge so we can all have confidence in the outcome of the trial. Because justice matters. Friends, as always, please stay safe, please stay tuned, and I look forward to talking with you all again tomorrow.